morning and welcome to an oral argument session for the 5th District Court of Appeal. We have one case on the docket here at 10 o'clock. I want to introduce the other members of the panel that are with me. My name is Rand Wallace. I'm from Orange County. We also have on this panel a Judge Eric Eisnagel from Seminole County and Judge Dan Traver, who is from Orange County as well. The case is Jeffrey Sadowski versus Carolyn Weinstein. And I'm going to assume the appellant would like a 5-minute rebuttal. Please let me know if you would like a different time than that. Obviously, we have, so everybody can see the clock. Anyways, Mr. Christopher, when you're ready, you may start.
Thank you, Your Honor, and I would like 5 minutes reserved. This is an appeal about a marital settlement agreement that was entered into by the parties back in July of 2014 and subsequently incorporated in a final judgment of the trial court in Seminole County in September of 2014. The issue for the court today involves paragraph 23 of that marital settlement agreement. The agreement was entered into by my client, Dr. Jeff Sadowski, and his former wife, Carolyn Weinstein. The agreement provides that the appellee will be granted 5% of Dr. Sadowski's interest in what's denominated in the agreement as an LLC, and that the appellee will receive 5% of the profit from my client's remaining interest in the LLC once it becomes profitable. At the time of this marital settlement agreement, the LLC was just a shelf corporation. It had never engaged in any business. It never had any activity. It just formed with the Secretary of State and was reflected in the SunBiz records. The LLC, in fact, was a PLLC. It was formed. Dr. Sadowski is a physician. He's an intensivist, and he formed it to practice medicine, although, again, he was working for Orlando Health at the time and did not activate the corporation. The PLLC remained dormant for 3 more years after the parties entered into their marital settlement agreement and after the trial court incorporated that agreement in its final judgment. It wasn't until sometime in 2017 that Dr. Sadowski activated the PLLC. He used it to practice telemedicine. He's an intensive care specialist. He contracted with smaller hospitals across the country to be on call and actually provide them with an intensive care specialist in a situation where with a small hospital, they couldn't afford to otherwise, they either didn't have one in the community or couldn't afford to have one on staff the whole time. In the next year, 2018, the appellee made a demand on Dr. Sadowski for her 5% interest in the corporation now that it was active and 5% of the profit in his remaining interest. He came to me. I looked at the parties' agreement and determined that they were really dealing with a PLLC, and in a PLLC, Florida statutes provides that you must be a professional practicing in the profession that the PLLC practices. And the client's former wife is not a physician and therefore was not eligible to be a member of that PLLC any more than any one of us as attorneys would be eligible to be a member of that PLLC. And so Dr. Sadowski declined to give his former wife any interest in the PLLC or to share any profits in the PLLC.
Mr. Christopher, if I may, I'd like to focus in on paragraph 23 of the full collaborative settlement agreement, which I'm assuming that's what you're talking about, correct?
Yes, Your Honor.
Okay. Specifically, the last sentence of that paragraph, the parties agree to resume the collaborative process to determine the proper tax and business structure to best effectuate the drafting process to accomplish this should the business become profitable in the future. So first off, you would agree with me that there's quite a bit of, I guess you would call it, good faith built into that paragraph number 23?
Well, there's good faith as far as the particular tax structuring of it and so forth. I would agree with that. I don't think that the language that you quoted refers to the fact that it's a PLLC rather than LLC, because the agreement doesn't, acknowledge that. And with a PLLC, it's my view that there's no way that you could structure it in such a way as to comply with the statutory requirement that all members be licensed professionals.
Well, in that paragraph, does that paragraph anywhere mention PLLC?
No, it mentions LLC, but the parties agree that Robotic Critical Care Services, PLLC, is the entity that was being referenced there, in that, even though it's not denominated correctly. In my opinion,
why wasn't it nominated correct or denominated or described correctly back when it was authored?
My personal view is that this was a may as well provision. It's paragraph 23 of a long agreement. There's a number of other provisions in there where the parties dealt with many significant items of property. This was a corporation that was just essentially a shell sitting on the shelf and had engaged in no activity at that point. So,
well, in that paragraph as well, the phrase ownership interest, I would like to focus on that as well, because if we're talking about, would you agree, if we're talking about an ownership interest in a PLLC, it's a different consideration and different requirements need to be met for the parties versus if we're talking about an ownership interest in an LLC. Specifically, if it's an ownership interest in a PLLC, then inherent in this factual scenario would be the fact that Mrs. Weinstein would have been excluded from any ownership interest if it had been described as a PLLC. Would you agree?
I would agree, Your Honor. And in fact, it was a PLLC and had been a PLLC for a year. It apparently got overlooked by both the attorneys and the parties when they were crafting paragraph 23. And
so are you calling that then a mutual mistake of fact? Is that correct?
Well, that's my characterization, Your Honor. I understand that contractually speaking, there's a whole doctrine of mutual mistake of fact, and I'm not saying that that's applicable here. That's just my offhand characterization of it, because I don't think it was raised by the attorneys. It wasn't raised by the parties. Nobody was aware of it. It was just a mistake that was made, because clearly it should have been denominated as a PLLC and should have put the attorneys on notice that this was something that couldn't be done.
In light of that characterization, what deference do we give to the trial court's finding that your client affirmatively misrepresented the makeup of the company during the collaborative process?
Because there's no evidence of that. I can't point to any evidence. The appellee stated that it wasn't discussed at all during the marital settlement agreement. My client said that he was aware that he had formed a PLLC, but he was not aware at that time that a PLLC was restricted in its membership. And therefore, I don't think that there's any evidence of an affirmative misrepresentation by my client, any reliance on that by the appellee, or any cognizance of that by the attorneys involved. And this is something that is easily checkable online by looking at Sunbiz. The attorneys certainly should have known that.
Council, what is tax and business structure? And I'm obviously talking about paragraph 23. It says tax, that the collaborative process will be used to determine the proper tax and business structure to best effectuate. I certainly, you sort of said earlier that that related to taxes, but what is the business structure part of that?
Again, I think if we were dealing with an LLC, there might be different ways to do it in terms of different types of membership. Their memberships, and certainly from a tax standpoint, you can allocate profits and losses in a whole myriad of ways. And I know just enough about tax to be dangerous, but I think that that's what that must be referring to is, again, depending on how you structure membership and what rights and responsibilities you give a particular member, it has tax consequences to that member. And the parties agreed that they were going to sit down and work that out, presumably in a way that was mutually advantageous to both of them.
So it's your position that business structure means, it doesn't mean LLC versus PLLC versus, S Corp and all the other various possibilities out there. That means within the company, who is vice president, who is president, who is on the board, that kind of thing?
Well, not just the identity of parties that are officers of the company, but again, the actual structure of the company, what rights do members have? What responsibilities do they have? Can they look at the books? Can they?
Sure. Council, can I ask you this question? Can the PLLC be converted to an LLC today? Is that possible?
Not continuing the practice of medicine. No, it's not possible.
And I'm not asking you about the current operations. I'm just simply asking you, is it possible to convert it?
As an entity, yes. The statutes certainly allow you to convert a PLLC to an LLC, but if you do that, then you can't have a physician's practice anymore.
Right. And
Is it possible?
And you agree those are potentially two separate issues. Perhaps, is it possible that your clients agreed here to convert this PLLC, or essentially agreed to convert the PLLC to an LLC, and then whatever operations can or can't continue are sort of a secondary issue?
I don't think that was the case, Your Honor. Candidly, I don't know. There's nothing in the record to indicate that.
I guess my point is that it's possible to perform paragraph 23, right? I mean, you concede that it's possible to perform it. You just convert it to an LLC.
Well, but if you did that, if you convert it to an LLC, they couldn't do business. It wouldn't earn any profits, and it would have no value to anyone whatsoever, to either party.
Well, I don't know if it would or not. I assume that the company may or may not have assets. I'm not sure whether we even know whether it would have any value. I'm just simply asking the question. You agree that it's possible to perform paragraph 23, even though that might mean the company has to discontinue its current operations, correct?
That's correct, Your Honor. And what the appellee would be left with then is an interest in a worthless corporation.
Is it possible for your client or another physician to hold the opposing party's ownership interest in trust and still continue the PLLC?
No, I don't think so, Your Honor. Again, I would go back to the Henry Adams bankruptcy case that we cited, where an attorney tried to get around the statute by having the interest in his law firm held as tenants by the entireties with his wife. And the bankruptcy court, again, relying on the first district's opinion, found that in Florida, you just can't do that. You can't circumvent the law by that attempt.
Will that be different than holding it in trust, wouldn't it?
It would be different, but I don't think that it would be any different. I think it's the same thing. It's trying to circumvent the law. The statute is pretty clear that you must be a physician to be in a physician LLC. And just because you set up another trust would be a backdoor way to evade the statute. And I don't think that the law allows for that.
Do I understand the record correctly that your client did not agree to resume the collaborative process pursuant to the last sentence of paragraph 23?
Right, and that was on my advice because I deemed it to be, there's nothing that they could do. There's no way you could fix this error.
Does that constitute an independent breach of the agreement?
It's, no, I don't think it's an independent breach of the agreement because again, it's an exercise in futility. And I don't think that the law requires you to engage in such an exercise just merely because an agreement provides for it. And in fact, this was mediated subsequent to the filing of this appeal pursuant to order of this court and the trial court. And the mediation was unsuccessful. And no one's come up with an idea that I've heard of that gets around the difficulty that this is a PLLC, and to engage in a physician practice, it must be a PLLC. That's the only business that's ever been engaged in.
And Mr. Christopher, you're into your rebuttal time, so I don't know if you want to reserve.
I'll reserve the last 5 minutes. Thank you, Honor.
All right, thank you. Ms. Wexler?
Yes, good morning. May it please the court. I wanted to highlight something that has not really been focused on in the appeal, or for that matter, even at the trial court level, although I suspect that the trial judge was very cognizant of this situation, that this was a collaborative settlement agreement. And this is now actually codified into law, signed by Governor Scott in 2016 and became effective in 2017. Although after the signing of this agreement, many divorces were participating. The process was in a collaborative setting. A collaborative, for those of the court that don't know what this means, collaborative process is a series of meetings. The couple come together with their attorneys. There's typically a financial neutral and a mental health neutral, and they operate as a team. And the goal of the team is to come up with a settlement agreement at the end of the case. Everybody signs collaborative participation agreements, and those agreements also say that
So why don't you tell us how paragraph, in your view, how could paragraph 23 be performed?
So paragraph 23 very specifically says, as Judge Wallace said, to reconvene the collaborative process and to determine what business structure would best, tax and business structure would best serve the intent of that paragraph. No effort was made in that regard. To accomplish this, I don't know that I agree with Mr. Christopher that the only way that physicians can practice together is in a PLLC. I think there are a number of entities out there that are PAs or LLCs that might own something else like a PA, but the point is that the purpose was to reconvene. It is in the spirit of the same collaborative process to get together and figure out if there's a problem. And I would point out to the court that Mr. Sadowski admitted under oath that he formed the PLLC a year before, that Mr. Christopher was his attorney in forming that entity. He always had Mr. Christopher. If you look at Sunbiz, Mr. Christopher is the person that helped him form the LLC or the PLLC.
Question.
Yes.
In paragraph 23, ownership interest, is it your position that the interest described there, is it technically a position of ownership in the business, or is it a right to the proceeds of the business?
It is a right to the proceeds. And we actually cited a case, I believe it was the Siegel case, that talked about that, where the husband in that case transferred all of his right, title, and interest in a home that subsequently, there was a construction litigation going on with the home, and he demanded a share of the proceeds of that litigation, and the court found that he's not entitled to it because even the proceeds from that litigation regarding the house for which he had transferred all of his interest was the former wife's, not the former husband's. And that's the Siegel case in my answer brief, Your Honor. So I would say that, and I would also point out, Mr. Sadowski transferred or gave one of his non-physician employees money. He gave her $3,000 the first year, and he called it the 5%. And there were documents that were entered into evidence that showed that Ms. Garzon was a 5% owner of that entity, which he suddenly changed after we filed the motion to enforce the agreement. And then what he did was he gave Ms. Garzon a bonus of $8,000 after that. Not an ownership interest, but he gave her a bonus. So in essence,
those seem like factual arguments instead of legal arguments. Give us a concrete example. Let's assume for a moment that we read paragraph 23 to require a collaborative process where the two parties will essentially try to figure out a way to draft, right? A way to make paragraph 23 happen. Okay. Let's assume for a minute that the court might interpret paragraph 23 in that way. Give us a concrete example of how it's possible legally for your client to own 5% of this company. Walk us through one example.
To own 5% of this company. That's not what it says. It says she's entitled to 5% of his ownership interest. So
Okay,
I'm
well,
not sure that she owns.
Walk us through, give us a concrete example of how paragraph 23 would work.
So what you could do, I suppose, I'm a little on the spot here since this is not my area, but I would say you could adjust the articles of incorporation. You could adjust the operating agreement. In this, you could reform this entity to be a PA as opposed to a PLLC. I believe you could call it an LLC. I think there are lots of physicians that practice under LLCs.
What's the authority for the proposition that the company could continue to operate as it is now as an LLC or as a PA? Can you give us a citation to a statute or?
I don't have a citation to a statute. I think that I think there's nothing that prevents my client from owning a portion of or having an interest in the LLC. The PLLC it's an operating agreement. The way the statute reads, as I remember, it just says that they are of the same profession. It doesn't specify a doctor or an attorney or an accountant or anything else. It only says they're of the same profession. I made the argument.
Which is the case here, right?
Pardon me?
Your client is not a medical doctor, correct?
She's not a medical doctor, but she is a nurse practitioner. She's certainly in the medical field and a professional in the medical field.
It certainly doesn't look like that would work under the statute. Let me ask the question in a different way. Let's say that it had gone according to the agreement. Y'all had reconvened the collaborative process. You've gotten the financial neutral who's there for the purpose of brainstorming and trying to resolve this particular issue, which is the idea behind the collaborative process. What if that financial neutral said, there's nothing that we can do here? Where does that leave your client?
What that does is that says, okay, if there's nothing we can do here, I made a bargain. Let's figure out a different bargain. Let's figure out a different way to get her the money. There are all kinds of ways to do that. For example, if Dr. Sadowski had monies in a retirement account that maybe my client didn't get initially, they could redo that piece. The problem here is that Dr. Sadowski never asked for any of that. He didn't participate. That's the problem. And although Mr. Christopher has made the argument that you couldn't possibly comply with this agreement, he never sought affirmative relief. He didn't preserve the issue.
So is the affirmative relief in that situation that Judge Traver posed to you after you've had a chance to reconvene and try and comply in good faith with paragraph 23 is to approach the court for some type of amendment to the marital settlement agreement?
Absolutely. And that's what the case law says. It says you can seek reformation. You can say there's a mutual mistake here. We made a mistake, court. What do we do with this? We need you to fix this. Or if we couldn't come up with an agreement in the collaborative, after reconvening the process, the options were limitless. The problem is Dr. Sadowski didn't want to participate.
Is there any, I don't think it's specifically spelled out in paragraph 23 or anywhere else in the settlement agreement, but is there any type of time limitation that's built into that settlement agreement as far as when the parties must undertake to try and resolve whatever inherent defect there is, such as in this paragraph 23?
It does not. It only says once the LLC becomes profitable. And there's nothing here there's no provision in the agreement or in this, and specifically in this paragraph that says he's required to, he being Dr. Sadowski is required to provide profit and loss statements to the former wife or his tax returns or anything like that. What we do know is, and what prompted my client to initially seek the reconvening of the collaborative process was she learned he left his old job and he was working full-time in this company. Well, I think it's a natural assumption that if he's working full-time in this company, that it might be profitable. There might be something there.
Were the profit and loss statements, were those a yearly thing, a yearly reporting requirement under the marital settlement agreement?
There is no requirement at all under this. We got it only as a result of the court order enforcing the agreement.
Counsel, the appellant argues that the provision is void because it's contrary, because they argue it's contrary to Florida statutes, therefore it's void. Could you address that argument and also severability?
First of all, both arguments were never raised except in the closing argument. He never sought to have the paragraph declared void. He never sought to have it severed. Mr. Christopher only made that argument in closing and I objected to it, so he didn't preserve it. So, and again, it also flies in the face of the spirit of paragraph 23. You're supposed to get together and try to figure out how to do this. If you can't do it, then you go seek some kind of remedy from the court, having it declared void or reformed or something like that. All of the cases that Mr. Christopher cited in his brief talk about things that are kind of obvious, like a gentleman who contracted with his mistress and said, I'm going to marry you in a year. And you know, we're not allowed to do that. It's the bankruptcy case. That was obviously somebody trying to have categorized exempt property in a bankruptcy case that was clearly not exempt property. That's not what happened here. And so, you know, the fact that it's a quote PLLC is only a structure. It's only a corporate structure. There are many other corporate structures under the Florida statutes that this company could have operated under. They selected PLLC, and so that's what we were left with. Although Dr. Sadowski at the time he signed this agreement knew it was a PLLC, he just didn't say anything.
Anything further, counsel?
No, let me just quickly take a look at my notes and make sure. I wanted to address a comment that Mr. Christopher made. He said that the appellee made a demand in 2018 for her 5%. That's not what she did, and that's not the evidence. The evidence is that what she asked for was a reconvening of the collaborative process pursuant to paragraph 23. She didn't make a demand, as he put it. He also said that there was that the trial court found that Mr. Sadowski had affirmatively misrepresented the structure of the business. And as I pointed out, he admitted that he formed it a year before. He knew that it was a PLLC. He had Mr. Christopher form it for him, and he had Mr. Christopher available to him to consult with during the collaborative process. So he just didn't take the steps that he needed to make sure that this paragraph, he said, I'll give you this. And in fairness to the former husband, he's a doctor, and maybe he didn't know what the difference between an LLC and a PLLC is, but he had an attorney who did. And he had an attorney who formed the entity for him. And he either talked to him or didn't talk to him while he was going through this collaborative process. But he did talk to him after he got served with or after he got notice that my client was seeking to enforce this provision. And he was told to ignore it, to not even participate in the collaborative process that's called for in paragraph 23.
Anything else, Ms. Wexler?
No, thank you, Your Honor.
All right, thank you. Mr. Christopher?
If I may, Your Honor, I want to correct a couple misconceptions that Ms. Wexler had. First off, I was not the attorney who formed this PLLC. I didn't start representing Dr. Sadowski until 2018 when his former attorney.
I'm not sure that we viewed that as terribly relevant to the appeal anyway. Let me ask you this. On your voidness argument and the severability, I'm not sure that the trial court even made it that far below. If you think I'm wrong, tell me why you think I'm wrong on that. If the trial court didn't make it that far, then it seems like perhaps that issue isn't before us.
Well, I don't know exactly how far the trial court did. The trial court basically enforced this provision, notwithstanding the statutory prohibition, and directed the parties that not only should they engage in the collaborative process, which in fact they've now done, but that also my client had to pay monies to the appellee and had to provide the appellee with financial information.
Did the trial court rule on whether or not paragraph 23 is void because it is against Florida statutes?
No, I made that argument and the trial court did not address the argument. The trial court,
What doesn't that mean that the argument wasn't even reached by the trial court and therefore not really before us yet?
I don't think so, because I think that the trial court disregarded that argument, and because it's necessarily contradicted by the trial court's ruling that the appellee is entitled to money, to information concerning the operation of the PLLC, and therefore I think that if you have that ruling is necessarily excludes a ruling that this is void and therefore severable. If this is void, and I think it is.
A ruling requiring discovery type materials doesn't seem to be the same thing as the trial court ordering your client to transfer an interest in the company.
No, but he ordered my client to pay money, which is a financial interest in the company, which Chapter 621 precludes as well. In other words, 621 says you can't do through the back door what the statute says you can't do through the front door. And through the front door, in a physician's practice, every member has to be a physician. And that there's no other way around it. Now, in this case, when I came on the scene, I looked at the operating agreement that Dr. Sadowski had, and he had his employee, Diane Garzon, his administrative assistant. He gave her I think what they denominate a financial interest in the corporation of 5%. And I said, you can't do this. This is contrary to the statute. And as a result, Ms. Garzon relinquished that agreement. And because, again, I don't think that that is lawful. And as far as converting the corporation, if you look at chapter 621, 621 provides that what was formerly known as PA is now a PLLC. You can
So
call
let me
a
ask you
PLLC
this.
a PLLC.
Let me ask you this, because, and it's the same question that I asked Ms. Wexler. Let's assume that your client had actually followed the agreement and reinitiated the collaborative process. And the financial neutral said, you know what, Mr. Christopher's absolutely right. There's nothing that we can do here. What's the result of that? We just read this out. We just read this out of the agreement.
Yes, Your Honor, I think you do because of the severability clause. Now, the parties could have.
How do we
spent the money to
address,
formally
how do we
go back to
address, sorry, Mr. Christopher, how do we address then the other acts clause in the agreement, which basically says, hey, we're going to perform any other acts that are reasonably necessary or maybe reasonably requested to effectuate the provisions of this agreement?
Right. But my position is there are no such acts in this, that there was a mistake made here, that the parties agreed on something that was unlawful, and therefore there's no workaround to that
Does your
problem.
client's ownership interest have value?
Does it have value? Sure.
Yes, sir.
Yes.
Is value fungible?
Value is fungible, but again, this agreement was entered into in 2014. The corporation didn't even start business until 2017, 3 years later. So at the time, it was contemplated that this company might never have any value whatsoever. So yes, it has value, but I think that the fact that the company specifically subsequently achieves value does not mean that you go back and renegotiate the whole agreement. This is paragraph
Counsel,
20.
I have one more question. I know you're out of time, but I do want to ask this question. Is it possible to effectuate paragraph 23 by selling the practice?
No,
Why not?
because who would buy the practice? It'd have to be another doctor. The practice is only worth, it's not unlike an attorney's practice. They are sold occasionally, but in reality, it's not like a widget factory. If the attorney's not there working, if the physician's not there working, the practice has no value.
Okay, I mean, counsel, I'm struggling with an argument that a doctor's practice cannot be sold. Is that your position?
No. I'm saying you can sell it. But again, in this agreement, why would the practice be sold?
I'm asking you. Can
Well,
paragraph 23 be effectuated by a sale of the practice? That's my question.
no, I think it can't. That a liquidation of the practice would be beyond what was contemplated in paragraph 23.
She'd be able to get her 5% of the ownership interest though, wouldn't she? In terms of liquidated value?
Sure, a one-time liquidation, yes, you could do that. But again, that would be contrary to the statute. A physician can sell his practice or can agree in a marital settlement agreement to give a certain amount of money. And if you look at this agreement, there were some true-up agreements reached in this, but I don't think that paragraph 23 contemplates that if in the future the business becomes profitable, that the husband will sell it and the wife will get 5% of the sale proceeds. And then the business is no longer in operation and can't generate any more profits. Makes no sense to me.
Does paragraph 3 guarantee the continued generation of profits? Where is that language?
It's not guaranteed, Your Honor. But
Well,
again, I guess one result could be that the PLLC is sold and liquidated, and I would submit to the court that based on my understanding, and again, this is not evidence, but there'd be very little resulting equity realized out of that, but it could be sold. And Dr. Sadowski could then form a new PLLC.
I guess here's kind of the point. Wouldn't all these issues, if they're possible, isn't this where they would be hashed out at the collaborative process that the paragraph 23 expressly calls for?
There was a mediation, Your Honor, that's already been conducted. And basically, nobody came up with any ideas
Was there a
how this
financial,
could be done.
was the financial neutral that was part of the collaborative process, or any financial neutral at the mediation?
There wasn't a financial, it was former Judge Evans that.
Right, but there's nobody who was like the systemic in the collaborative process is that everybody works together and you have neutrals that don't have a side that are able to brainstorm these issues. You've got an obligation to your client to zealously advocate in his interest. And you may be right, Mr. Christopher. You may be 100% right. There may be no corporate way to do this. I'm skeptical, but you might be right. But isn't the whole idea of the collaborative process that you get somebody neutral who tries to bridge this particular gap and figure out that there is a way?
That could be, but that's not what the trial court did here. The trial court fashioned its own remedy. And my view is that given the situation and the statute that we're dealing with, that it would be a futile and a waste of time to engage in a process that, again, I haven't heard the first idea. The other side has not proposed any business structure that would accommodate the statutory requirement that would allow Dr. Sadowski to continue to practice in this PLLC and yet provide a 5% ownership interest to his former wife. It can't be done. And there's nothing that I can see that's been suggested at any point by anyone as to how that could be done, other than what the trial judge did, which was ignore Chapter 621 and say, well, you said you're going to give a 5% ownership interest, you got to pay her 5%. And that's contrary to statute and the case law, which I cited from the Supreme Court on, has been consistent in Florida. That.
Thank you, counsel. I think you've answered our questions.
Thank you.
And that is the end of this oral argument session. Thank you, counsel, for your arguments. Have a great day.
Thank you, you too.